The Law Commission has recently released a report strongly supporting the retention of the sedition law in India. According to the Commission, repealing Section 124 of the Indian Penal Code, which encompasses the sedition law, would disregard the existing ground realities in the country. The report recommends that the punishment for sedition be increased from 3 years in jail to a life term or up to 7 years in prison. The sedition law had been challenged in the Supreme Court, which suspended criminal trials and court proceedings under the law last year, allowing the government to review it. In response, the government sought the Law Commission's opinion on the law. The Commission's report argues that the sedition law plays a crucial role in combating anti-national and secessionist elements, aiming to protect the elected government from attempts to overthrow it through violent and illegal means, while acknowledging the need for procedural safeguards to prevent misuse of the sedition law. The report states that allegations of misuse alone are not sufficient grounds for its repeal. The report also addresses the argument that other laws are in place to handle charges of activities deemed anti-national. According to the Commission, the Unlawful Activities Prevention Act and the National Security Act do not comprehensively cover all elements of the offence defined under Section 124 of the IPC. Furthermore, the absence of the sedition law would lead to such cases being tried under more stringent counterterrorism legislation. The Law Commission emphasizes that each country's legal system deals with its own unique realities and asserts that basing the repeal of Section 124 solely on the fact that other countries have done so would ignore the specific ground realities in India. Regarding the colonial legacy argument against the sedition law, the report suggests that labeling a law as colonial does not necessarily render it obsolete, as many aspects of the Indian legal system have colonial origins. The report argues that the colonial origins of a law should not automatically validate the case for its repeal. The report acknowledges instances of misuse of various laws for personal vendettas and vested interests, but notes that there has never been a plausible demand to repeal such laws solely based on their misuse. Instead, the focus should be on introducing legal mechanisms to prevent misuse while ensuring the protection of genuine victims of offences. In conclusion, the report highlights the need for measures to prevent the misuse of the sedition law rather than its outright repeal. For more such news and updates, subscribe to our YouTube channel.